appearances from the plaintiff?
Yes, please.
Good morning, Your Honor. My name is Abigail Poon, and today I'm joined by my co-counsel, Miss Odelia Bergner-Phillips. Good morning, Your Honor.
Hello.
And Miss Samara Saggers.
Good morning, Your Honor.
Together, we represent the plaintiff, Mr. Shannon Shahid.
Good morning.
Hello.
Would you like to hear appearances from the defense before we
Thank
reach
you.
Your Honor, my name is Arusha Mascara, and I'm here today with my co-counsel, Mahati Chitli,
Good morning, Your Honor.
and Kaylee Kim,
Good morning, Your Honor.
and together we represent the defendant, Taylor Hobson.
Good morning.
Taylor Hobson is a party representative in our case today.
Thank you.
Pretrial to the plaintiff, Your Honor.
Yes, please.
First, Your Honor, we'd like to tender a bench book. It includes all relevant case law, stipulations, any rules of evidence that Your Honor might refer to throughout this round. May my co-counsel approach? At the end of that bench book, I believe we have a gender pronouns form to keep track of all the witnesses and attorneys in today's round. Next, Your Honor, we'd like to read onto the record stipulation 6. If you flip to the stipulations tab, it's on the first page.
Getting micromanaged.
Stipulation 6 simply states that exhibits 6, 7, 10, 11, 12, 18, 20, 21, 37, and 42 are pre-admitted. Both parties stipulate that all pre-admitted exhibits may be used or referred to during opening statements.
Okay. Is that your understanding as well?
Yes, Your Honor.
Okay.
Next, Your Honor, we'd like to inquire about your preferences in terms of moving about the well. Are we free to move about the well, as well as should we ask for Your Honor's permission before we approach the witness or approach the bench?
No, I don't think you need permission to approach, and you can use whatever part of the code you like.
Absolutely, Your Honor. And lastly, we'd like to invoke Rule 603 and 615, the constructive sequestration and swearing in of all witnesses, barring party representatives. Today, Mr. Shannon Shahid is our party representative.
Any objections?
No, Your Honor.
Okay, that's fine.
That's all from the plaintiff, Your Honor.
Your Honor, the defense would like to bring your attention to a few more stipulations.
Okay.
First, I'd like to bring your attention to stipulation 7, which states that all hearsay objections have been made to exhibits 22, 23, 24, 31, and 35. Next, I would also like to direct your attention to stipulation 22 and 29. Stipulation 22 states that at the time of his death, Avery Bancroft was worth approximately $404 million. And stipulation 29 states that both parties agree that this trial is not bifurcated. If the plaintiff prevails in this case and the defendant is found liable, Shannon Shahid will inherit the entirety of Avery Bancroft's estate.
Do you take any exception?
That's plaintiff's understanding as well, Your Honor.
Okay, thank you.
We'd also like to inquire about a few more preferences of Your Honor.
Sure.
The first one is, after objection, should we motion to strike or receive stricken?
Say the truth, I think you should move to strike, because most attorneys never remember to do that. It stays on the record, and it's not removed. The jury, although told not to consider it, gets reminded of the counsel.
Yes,
So
Your
I
Honor.
would move to strike.
And we'd also like to inquire if we can refer to Your Honor as both judge and jury.
Sure.
That's all the defense has.
Okay, I guess for my purposes, are you finished?
Yes, we're okay.
My name is Matthew Rogolsky. I've been a judge for 4 hours. I was a prosecutor for 25 years in Mercer County. Before that, I did both prosecutorial work in a county, up in Warren County, and then for a project firm in Warren County as well. So basically, I'm a retired prosecutor. This is attorney. What was her name again? Misty Redovich. She's a relatively new attorney, just got sworn into the bar. And her husband, Kyle. Kyle Cogden, he's been an attorney approximately 10 years. He engaged primarily, if not exclusively, in civil situations. So he's gonna know all the answers. I'm just gonna know criminal stuff and evidence. But other than that, any questions, any issues about recusal or anything like that? Does anyone know myself or the other judges?
I think we're ready to begin, Your Honor.
Seeing no objections, we will begin. I would ask other party, I was not aware or made aware of any time limitations. Are there time limitations on each of your presentations?
Yes, there are, Your Honor. We have timekeepers telling us how to keep track of things.
Okay, so how long will they have for opening?
There are 15 minutes allotted to statements, and then they can allot opening and closing however they wish.
Okay, thank you. Whenever you're ready.
Commissioner, to proceed?
Yes.
May it please the court. She wanted the money, so she needed to kill. It's April 21st, 2024, and the defendant, Taylor Hobson, is on a train ride traveling through Australia. But she's not there for a vacation. No, she's there for money. You see, the defendant is $600,000 in debt, and she's got no job, no source of income, and no shot at balancing the books except for her multi-millionaire father, Avery Bancroft. And so she's followed him onto this train, cornered him into the dining hall, and now she's begging for money. But Avery Bancroft says no. Even worse, the defendant learns that she's being cut out of the will, meaning that she's losing out on hundreds of millions of dollars, losing out on her last hope of living a lavish life, a life that she would kill for. And members of the jury, you'll learn that that's exactly what she did. Just 4 days later, before he could change the will, Avery Bancroft is found dead, poisoned in his cabin. Because the defendant wanted the money, so she needed to kill. Now, members of the jury, the law is clear. If you're responsible for someone's death, you can't inherit any of their money. Now, this law is called the Slayer Statute, and it's the reason why we're here today. To disqualify the defendant from receiving any portion of her father's inheritance. And to do this, we have to prove one thing, that Taylor Hobson knowingly caused the death of her father. And we have to prove this by what's called the preponderance of the evidence, which just means that this was the case more likely than not. And we'll prove our burden today by showing you that the defendant wanted the money, so she needed to kill. Now let's start with that first part, that the defendant wanted the money. Today, you'll hear from another one of the passengers on the train, Miss Harley Kim. Miss Kim will tell you that every time she talked to the defendant, the topic of conversation was always the same. It was the inheritance, because the defendant thought that Mr. Bancroft was squandering his wealth, which in turn was squandering her inheritance. And the defendant wanted the money, so she needed to kill. And after Harley Kim tells you what she heard, she'll tell you what she saw. A bottle of potassium in the defendant's cabin. Next, you'll hear from Dr. Hillary Edmond, who will tell you that for Mr. Bancroft, potassium was poison. You see, Dr. Hillary Edmond is a medical expert and was one of the first responders on the scene for Avery Bancroft. Dr. Edmond will tell you that Avery Bancroft was diagnosed with chronic kidney disease, an illness that meant for him, ingesting potassium could be lethal. And for him, it was. Dr. Hillary Edmond will tell you that Mr. Bancroft's death aligned perfectly with severely elevated potassium levels and aligned perfectly with a poisoning. And finally, you'll hear how the bottle of potassium ended up with the defendant. Private investigator Jordan Nathanson will take the stand, and she'll tell you that she found a receipt on the train that included the purchase of potassium. And at the time of purchase, every single passenger was on the train except for one, the defendant. Ms. Nathanson will tell you that she found a bottle of potassium in the defendant's cabin, and after Mr. Bancroft died, this bottle was empty because the defendant wanted the money, so she needed to kill. Now, members of the jury, the defendant isn't the only one who wanted something. This is Shannon Shahid, Mr. Bancroft's only other child. No, you won't hear from Mr. Shahid today, but I want you to think about what he wanted. And it's not money, it's not inheritance. It's to be able to spend time with his father. It's for his future children to meet their grandfather. It's for his family to be together. But because of the defendant, because of her actions, because she wanted the money, because she killed, Mr. Shahid will never get what he wants. Now, it's much too late to give Mr. Shahid the justice that he deserves. So today, we ask that you give him the only justice he can get and find the defendant liable. Thank you.
One moment, please. Please.
Your Honor, members of the jury, may it please the court. A favor for a fortune. On April 25th, 2024, Taylor Hobson entered her father's cabin to find him lying on the floor. Moments later, she lost her only father and remaining parent. Their time on the Mid-Riverina Express was supposed to be a time for a family reunion, a time where father and daughter could reconnect and reconcile their differences. But because of a favor owed, their time was cut short. Shannon Shahid cashed in on a favor in order to get his hands on a larger inheritance. What evidence will show you today is that Shannon Shahid repeatedly asked his father for money over the years and asked him to spare tens of thousands of dollars. But every time he was asked, he was denied the money. This left him in a position where he needed to find the money, and he needed to find it fast. Luckily for him, Ashley Connell was aboard the train that day and aboard the train on the same time that Bancroft was. She was also losing money every single month, fighting a defamation lawsuit against Bancroft. You'll hear from witnesses that Ashley Connell wanted to find her way out of this lawsuit as quick as she could. Ashley Connell did a favor for a fortune. On the 22nd of April, the Mid-Riverina Express left Sydney and started their passage through the Australian outback. The passengers were excited and relaxed, and Taylor Hobson was hoping for a time to reconnect with her father. But quickly into this trip, Shannon Shahid started strategizing his plan to kill Avery Bancroft. The following day, the second day on the train, Ashley Connell went to lunch with Lori Shelton in Silver City. You'll hear from Lori today as she testifies to the fact that Shannon Shahid was a close friend of Ashley Connell. She'll testify to their communications and to their friendship, and we'll also talk about their calls and texts that they had during this lunch. Not only that, but Lori will talk about the final favor that Shannon requested of Ashley that resulted in Bancroft's death 2 days later. Now back on the train, Kelly Dews, the partner of Taylor Hobson, went to lunch with Taylor and Bancroft on the train. Now during this lunch and months prior, Kelly Dews will talk about the strained relationship between Shannon and Bancroft and the fact that, and the money that Shannon has been requesting from Bancroft over the years. She will also talk about Shannon's disdain for Bancroft that stemmed from the lack of financial backing that Bancroft supported Shannon. And lastly, you'll hear from Taylor Hobson, who tragically lost her father that day on the train. On April 25th, 2024, Taylor Hobson lost her father. Now Taylor will talk about the absurdity of these claims that Shannon is bringing forth, and the absurdity that lies in the fact that Taylor had to traumatically watch her father die, yet is accused of killing him. She will talk about both her lack of motive and means in this matter. And again, we'll talk about the absurd accusation that the plaintiff is bringing forth. Now, the plaintiff is bringing forth a lawsuit pursuant to the Slayer statute, which means that any person responsible for killing another person may not benefit from the death. In doing so, the plaintiff must prove by a preponderance of evidence that Taylor Hobson killed her father. This means that only they hold the burden of proof. If you find yourselves 50-50 on the matter at the end of this trial, you must find Taylor Hobson not liable. Luckily for you, the evidence today will show that Taylor Hobson did not kill her father. Rather, Shannon Shaheen cashed in on a favor for a fortune. At the end of this trial, my co-counsel Mahati Chitty will come before you and ask you to find the only verdict that has been compelled by the facts of this case, and will ask you to find Taylor Hobson not liable.
Thank you. Please call your first witness.
At this time, the plaintiff calls Harley Kemp to the stand. Permission to proceed?
Yes.
Good morning.
Good morning.
Could you please introduce yourself to the members of the jury?
Sure. Well, hi there. My name is Holly Kim.
And what do you do for work, Miss Kemp?
Well, I'm a photojournalist for Blitz News Network, or BNN. I don't want to brag, but we're the #1 source for news here in Midland.
How did you get into photojournalism?
Well, I don't know, I guess you could say it was a little bit out of necessity. See, when I was little, my mom, she loved taking home videos of me and my sister, but the woman, bless her heart, could not hold a camera steady. So one day I just picked up the camera myself, and I don't know, ever since then I've just loved taking important videos for people.
Then I want to talk about today's case. Do you know why you're here, Miss Kemp?
I've been asked to testify about my time on the Mid-Riverina Express. That's the train I took in Australia earlier this year.
Could you tell us a little bit more about that train ride?
Sure. I mean, I was located in the Platinum section, and I definitely see why they call it the Platinum section. It was luxurious, to say the least. It was me and 11 other passengers, and we had private rooms, we had a special dining area with a gourmet menu, we had guided excursions, and we were completely separated from the rest of the train. So it really felt like we were in our own little world.
Did you recognize any of the other 11 passengers on the train?
Yeah, there were a couple of familiar faces, most notably, obviously, being Mr. Bancroft. That's the passenger who passed away during our trip.
How did you know Mr. Bancroft?
Well, Mr. Bancroft was a pretty prominent businessman here in Midlands. I knew he had a family, he owned a couple properties, but I had never actually met him before the train ride.
And you mentioned Mr. Bancroft had a family. So were any of these family members on the train with you?
Yeah, that's actually where I met his daughter, Taylor Hobson.
Did you ever see any interactions between the defendant, Taylor Hobson, and Mr. Bancroft?
I did. On our first night on the train, after dinner, I saw Mr. Bancroft and Miss Hobson talking to one another, and then they started raising their voices and getting into an argument, and I couldn't hear exactly what was going on, but the whole thing ended with Mr. Bancroft just storming right off.
Do you know what they were arguing about?
I don't know what that argument was about exactly, but a little later on in the trip, Miss Hobson talked to me about some of her troubles with Mr. Bancroft.
And what did Miss Hobson say about her troubles with Mr. Bancroft?
Well, she just went off on a rant. She said that Mr. Bancroft, well, he was a failed businessman, and she blamed him for losing $1 billion for their estate. She said that if Mr. Bancroft were left to his own devices, well, there just wouldn't be any family estate left. I mean, let me tell you, all she talked about was money.
So you just told the members of the jury about Avery Bancroft's will. So now I want to talk about Avery Bancroft's health. Did you know anything about it?
Yeah, on the third morning of the trip, I overheard Mr. Bancroft talking about potassium.
What did Mr. Bancroft say about potassium?
Well, he said he planned to reduce his potassium intake for health reasons.
Objection, Your Honor. Under Rule 801, this is hearsay. This is an out-of-court statement being used for the truth of the matter. The statement here is that Mr. Bancroft would like to reduce his potassium level, and that is an out-of-court statement used.
Your Honor, if I may respond?
Yeah.
This is not hearsay because the statement falls under Exception 8033, plan, intent, or motive. We're stating that Mr. Bancroft planned to reduce his health intake. So this is not hearsay because it falls under that exception.
I've never heard of an interpretation of hearsay under that exception for that reason. Usually it has to do with the planning of some event. Are you familiar with any exception to the rule?
Your Honor, if I may.
Of course.
In this case, the plan is Mr. Bancroft's plan to reduce his potassium intake. Mr. Bancroft said, I'm doing this. He never said anything. It's a plan that he's doing this. So that's the plan statement.
I understand your position. I don't think that exception is appropriate under the events as I understand it. So can you move on? Perhaps
Yes.
rephrase the question?
In that case, the defense would like to motion to strike this statement.
So strict.
All right, Ms. Kim, did you ever see any potassium on this train?
Well, yeah, later that night, actually. That day, we stopped off at a store, we had some dinner, and before the other passengers went back to their cabins, I decided to peek in Miss Hobson's room.
And what did you see in Miss Hobson's room?
Well, I saw this orange hoodie on the floor of Miss Hobson's cabin, and when I took a closer look, it was concealing this bottle of potassium.
And would you recognize this bottle if I were to approach you with it?
Yes, ma'am.
Approaching opposing counsel and the witness in turn with what has been previously marked as Exhibit 40. Ms. Kim, what is this?
This is a bottle of potassium extract, and it looks just like the one I saw in Taylor Hobson's cabin.
Is this a fair and accurate copy?
Yes, ma'am, looks like it.
Has it been changed or altered in any way?
No, ma'am.
At this time, the plaintiff moves Exhibit 40 into evidence.
Any objection?
Yes, Your Honor. We would like to object to anything other than the purpose of identification in this bottle, and would like to redact any other statement except the label that states that this is an abstract under hearsay.
Actually, I'm going to allow it. She's identified it as identical, if not the exact the motto. So I would suggest that it goes to the weight of the evidence for the jury as opposed to being admissible or not admissible for that purpose. You, of course, can argue it's not it or it's not enough. They can argue the opposite, but I think it's admissible in general.
Yes, Your Honor.
Ms. Kim, what is this?
Well, like I said, this is a bottle of potassium extract that looks just like the one I saw in Taylor Hobson's cabin.
And what happened after you saw this bottle of potassium?
Well, I just went straight to bed. I mean, I was exhausted. We'd had a pretty long day. So, when I woke up to screaming, well, I thought I was having a nightmare at first. I thought I was imagining things, you know, but, well, it kept getting louder and louder. So, I jumped out of bed and I grabbed my camera and I rushed out of the room. I mean, didn't even change out of my pajamas. I followed the screams to cabin 1.
What did you see when you got to cabin 1?
Avery Bancroft. He was lying on the ground when I got there. He didn't look right. I think there was some other people in the cabin too, trying to help Mr. Bancroft, but I was paralyzed. I mean, I didn't know what to do. The people trying to help Mr. Bancroft were too late. He passed away.
All right, Ms. Kim. Now, I want to take a step back and talk about motive. Do you know if there was anyone on that train who would have benefited from Avery Bancroft's death?
Objection, Your Honor, under speculation. This is not something that's rationally based in this witness's perception, and it's just simply a speculation that matters on the train.
I don't know, I think the question was appropriate. Maybe the answer might be inappropriate, you can move to strike then, depending on how she ties that up and how the witness ties it up. So, with that admonition, I would want to rephrase, or do you want to use the same form? That's up to you.
Your Honor, if I may use the same format.
Sure.
Ms. Kim, do you know anyone on that train who would have benefited from Avery Bancroft's death?
Well, I don't know. I guess there was that conversation I overheard, but that doesn't matter, right?
What conversation, Ms. Kim?
Well, the one I mentioned, the argument between Mr. Bancroft and Miss Hobson, where Mr. Bancroft stormed off. After that, I wanted to ask Miss Hobson some questions.
What did you ask Miss Hobson?
Well, we were just chatting, you know. I mean, it was cordial, both of us smiling, and then I asked her about this rumor I had heard.
What rumor?
The one about the will. I just asked if it was true, if Mr. Bancroft was really going to cut out of the will.
And how did the defendant respond to being asked about the will?
Well, the smile just dropped. That was that. She walked off. And then a little later, I saw the potassium in the room. And 12 hours after that, oh my God, that's when Mr. Bancroft, he died.
Thank you, Ms. Kim. No further questions, Your Honor.
Defense?
May I proceed? Good morning, Ms. Kim. My name is Rashina Scar, and I'm just going to be asking you a few questions on behalf of the defense.
Sure, good morning.
I'm going to start with your job.
Sure.
As part of your job, you were involved in a defamation lawsuit, correct?
Yes, I was.
And following that lawsuit, you were demoted?
Yes, I took on a different position. It was not quite as good as the one I was working before, but life's life.
You're hoping that by being here today and breaking this big story, you may be promoted.
Well, that's not quite why I'm here. I should mention I was subpoenaed. I would not be here today if I wasn't forced. There's about 1 million other places I'd rather be than in court.
But you're still hoping that if you break a large story, you could be promoted.
Well, I am a photojournalist, so that is typically how it works. Yes, ma'am.
I'm going to go on to the other passengers in the train. You conducted background research on all the passengers on the MRE, correct?
Yeah, some of the other passengers. I am a journalist at heart, so, you know.
And during that research, you found a lawsuit of Ashley Conlon.
Yeah, I came across that.
Would you recognize that lawsuit if I had it with me today?
I believe I would, ma'am.
Record reflect, I'm approaching the opposing counsel, the witness, and the bench with what has been marked as Exhibit 23. Is this that lawsuit?
Looks like it, ma'am.
Is this a fair and accurate representation of it?
I believe it is.
Has it been changed or altered in any way?
No, doesn't look like it.
At this time, the defense would like to motion to enter this exhibit into evidence.
Objection, hearsay. This out of court of statement is being used for the truth of the matter.
Your Honor, this is not being used for truth of the matter asserted. It's simply just to show a lawsuit between Ashley Connell and Avery Bancroft. And also, I believe that public records such as the lawsuit here are exempt from hearsay.
exactly what you represented, that there was a lawsuit between important parties or claimants, and that might set up a circumstance where motive might be considered.
Yes.
However, I am going to caution the jury that none of the information or allegations contained in here can be considered factual at this point in time. It's simply to set up a motive or the allegation of motive and not to prove what may be asserted in these paragraphs.
Yes, Your Honor. Simply the lawsuit itself at the time of it.
Okay.
Now, you mentioned you were involved in a defamation lawsuit,
Yes, ma'am.
and those lawsuits can get really pricey.
Well, I'm not an attorney myself, but I do believe you lawyers charge quite a bit.
Right, and you believe Avery Bancroft sued Ashley Connell to bury her in legal fees?
Well, I don't know a ton about this lawsuit, but from what I know, it would make sense if Mr. Bancroft brought this lawsuit to rack up a hefty price tag for the defendant.
And you don't know how much Ashley Connell has paid so far.
No, ma'am, like I mentioned, I don't really know much about this lawsuit at all.
Thank you, Your Honor. You can set that aside for now.
Sure, ma'am.
I want to move on to something you said in your direct, that you snuck into Taylor Hobson's cabin. Is that correct?
Yes, ma'am, that's correct.
Now, Miss Kim, you were an alcoholic, weren't you?
Well, ma'am, I've had some issues in the past, but I should mention, I've been sober for about a year now. I'm very proud of it.
But you periodically take sips from your glass?
Oh, well, that flask actually contains fruit juice. It's to help me break the habit. So I keep it on me, but there's nothing alcoholic in there.
Objection, Your Honor. Misleading. These questions don't use anything to prove a point here. It's just trying to mislead the jury to believe something about Ms. Kim.
Your Honor, if I may.
Sure.
This goes to the witness's credibility and therefore is extremely relevant to the facts of the case at hand.
Has to go to her credibility.
We're trying to, if I may proffer, my next question is about to be that she acted drunk when Taylor Hobson found her in a cabin, and I believe that her background as an alcoholic is relevant to that.
Your Honor, let me respond. Ms. Kim has already testified that she is not an alcoholic. She does not drink at the time. So therefore, this is a misleading question to make it seem like she was acting like drunk on the train.
So it seems to me that you're trying to say that because she is or was an alcoholic, and that's still up in the air, that somehow on whatever day you mean, day X, she was drunk?
No, Your Honor, I'm simply trying to say that she was an alcoholic and is therefore acting as an alcoholic when Taylor Hobson found her in a cabin, even if she wasn't drinking.
Your Honor, let me respond. They're saying that Ms. Kim was an alcoholic, therefore not she is right now, therefore that has no relevance to the situation right now.
Well, I agree with that. It has no relevance to her testimony right now. I just don't understand the relevance to her being drunk or not drunk at the time she was interacting with other people. Just being an alcoholic doesn't make you drunk on any given occasion. Do you have any other evidence of any other circumstance or any other witness that's going to tell us she acted drunk? Or are you going to get hurt from her testimony that she was drunk during that
No, Your
interaction?
Honor, however, we're just trying to say that, her character has been an alcoholic before, and that doesn't mean she was drunk necessarily right now, but it is a possibility.
I'm going to disallow that, and I'm going to, even without your motion to strike, I'm going to advise the jury that my understanding of where you're going is that she was or is an alcoholic, and on day X, she acted like an alcoholic, and you suspect she was drunk, and therefore, whatever she said, didn't say, saw, or didn't see, was affected by a mental condition or a disease. It may or may not have been extant at the time of that experience, so I'm going to disallow it.
Yes, Your Honor, and just to clarify, it's the second question that's stricken. What exactly is being stricken?
Okay, so
Motion to strike.
okay, can you please, do you want to repeat your question, or do you want to phrase it the way you might
If
understand?
opposing counsel could repeat the question.
Okay,
The question I had just asked is that, I was asking Ms. Kim, do you take sips on your glass periodically?
I would ask that opposing counsel rephrase and also motion to strike the testimony about Ms. Kim being an alcoholic on the train.
well, because she drinks doesn't make the question relevant, unless you're trying to establish that somehow on an important occasion, she was drunk. because you had independent evidence or evidence from her to establish that she was drunk at that critical time. You don't have that yet.
Right.
And unless you produce that, you don't have it. And I don't think it's right to ask the jury to assume that because she may or may not be an alcoholic, that she would be drunk in time period X. So I think the first question is irrelevant to the facts at hand. The second question is inappropriate because it doesn't establish anything that's relevant to this case.
Yes, Your Honor.
So if you could move on, or perhaps rephrase, it's up to you.
That's all right, I can move on.
Thank you.
Yes, Your Honor. Now, Ms. Kim, when Ms. Hobson died in her cabin, you acted drunk. Is that correct?
Well, I was a little embarrassed when Miss Hobson caught me peeping around her room, so I pretended to have stumbled in there, but I was not drinking at all on the train. I've been very strictly sober for the past year.
Now, let's talk about what you found in that cabin. You claim to have seen an orange hoodie and a bottle of banana extract.
Yes, ma'am. In Miss Hobson's room, I saw the orange hoodie on the floor, and it was concealing the bottle of potassium.
But you don't know whose hoodie that is.
No, just that it was in Miss Hobson's cabin.
And there was nobody with you to testify that those things were actually in that cabin.
No, ma'am. I mean, I'm under oath today, but there was no one with me to.
And you didn't take any pictures.
No, ma'am, I did not.
But a photojournalist's job is to document things.
Well, it was a bit of an impromptu excursion into Miss Hobson's room, so I didn't think to take any photos.
But you went into Miss Hobson's room to find dirt on Avery Bancroft.
Well, I was just trying to discover a little more about their relationship, but I wasn't there on any sort of official assignment, so I didn't think to take pictures.
But is that a yes to my question? You were there to find dirt on Avery Bancroft?
I was there to learn more about Avery Bancroft. I wouldn't say I was particularly looking for dirt, as you're putting it, but sure.
So that's a yes to my question.
Yeah. Sure, ma'am.
So, once again, you were a photojournalist looking for dirt, but you didn't document it.
Well, like I mentioned, I wasn't there specifically under my role as a photojournalist, so no, ma'am, I didn't take photos.
Thank you, Ms. Kim. No further questions, Your Honor.
Any follow-up?
No redirect, just at this time I ask that we publish Exhibit 40 to the jury.
Sure.
And I also ask permission for Ms. Kim to step down.
Oh,
Can I go ahead again?
sure. Just some advice to both counsel and whoever may hear. When you introduce a physical object, just out of courtesy, you should show it, bring it up to the court, so the judge, in this case judges, can see it, and just go look at it. Because often judges will take notes of objects that they see pass. If you just bring it up, you only see it from afar.
Yes, sir.
Has this been entered into yet? I'm sorry. Okay, please.
Your Honor, at this time, the plaintiff calls Dr. Hillary Edmond to the stand. Before we begin, Your Honor, we'd like to move to enter Exhibit 19A. That's Mr. Bancroft's autopsy to the jury. Pursuant to Stipulation 10, all objections to this exhibit have been waived and no additional foundation needs to be laid. Yes, that's Stipulation 10.
Is there any objection?
No objection, Your Honor.
Okay. Just checking for the record. Please
Absolutely.
continue.
Would jury like a courtesy copy? Good morning, sir. Could you please introduce yourself to the jury?
Hello, I am Dr. Hillary Edmond.
Dr. Edmond, tell us about your educational background.
Okay, I attended the Street School of Medicine. I then performed my residency. I am board certified in internal medicine, emergency medicine, and pulmonology. I then took some time off to take care of my family before returning to practice shortly after.
What's your specific experience working in medicinal practice?
Yes, so I worked at an emergency rescue clinic in the Himalayas. I served numerous kidney patients there. I then operated my own private practice and published a lot of research, including on kidney medicine.
Doctor, tell us why you're involved in today's case.
Yes, so I was on the Mid-Riverina Express, where Avery Bancroft died, where I both observed him. I was also the doctor on the scene when he died. And finally, I conducted a diagnosis and a cause of death analysis for Monsieur Bancroft.
All right, let's talk about that analysis you conducted. Was a cause of death ever determined?
Yes, based upon patient observations, based upon medical records, and based upon the autopsy, a cause of death was determined.
Would you recognize the results of that autopsy if I showed it to you?
I would.
Let the record reflect, I'm showing opposing counsel. And the witness in turn, with a copy of 19A, it's already been entered, Your Honor. Now, what can you tell us from those results?
So the autopsy identified a very severe level of potassium in Monsieur Bancroft as his cause of death.
Doctor, how does someone die from potassium?
Well, very high levels of potassium can poison the blood, resulting in cardiac arrest and death.
Doctor, is it possible that Mr. Bancroft's potassium levels just naturally rose, and that's what killed him?
No, madam. Potassium levels do not just rise. The human body does not produce potassium at all. All of the potassium in Mr. Bancroft's system, it had to be ingested.
Have to be ingested. Doctor, is ingesting too much potassium something we all have to be worried about?
No, not at all. Ingesting too much potassium is only dangerous for people with chronic kidney disease, as the kidneys can usually filter out too much potassium. But of course, Monsieur Bancroft, according to his medical records, had chronic kidney disease.
Doctor, could you explain how all this works to the jury?
Yes, I actually brought a model to help with that.
We should have Dr. Inman step down and make use of his demonstrative.
Any objection?
No objection, Your Honor.
All right, doctor, so what do we have here?
Here, I have a beaker. Think of this as the human body. I also brought some banana grams from my daughters at home. Think of this as Monsieur Bancroft's potassium levels.
How does the beaker get more full?
So we are here at normal potassium levels. At this point, one does not show symptoms of elevated potassium. However, if we add a little bit of potassium, voila, we reach mildly elevated potassium levels. Then we reach moderately elevated potassium levels. Next, we reach severely elevated potassium levels. And finally, voila, as the beaker is almost overflowing, we have reached very severely elevated potassium levels. This is where Monsieur Bancroft's system was at when he died.
Doctor, what's the difference between these levels?
So as your potassium levels increase, as the beaker is more full, you will show more and more symptoms of elevated potassium levels. You will show more irregular heartbeat, fatigue, muscle weakness, and finally, at the very severe elevated levels, cardiac arrest.
Doctor, what do we expect to see if there was a gradual increase in potassium levels?
Well, if there was a gradual increase in potassium levels over time, one would see the symptoms of elevated potassium levels gradually increase over time. But that is not what happened with Monsieur Bancroft.
What happened in Mr. Bancroft's case, doctor?
In Mr. Bancroft's case, he went from no symptoms on the train before his death to cardiac arrest and very severely elevated levels of potassium. It changed, it was day and night. All potassium has to be ingested, but whatever Monsieur Bancroft ingested must have been very rich in potassium.
Doctor, is it possible that Mr. Bancroft just forgot to regulate his potassium levels?
No, Monsieur Bancroft was taking potassium regulating medication, and also he was very carefully avoiding potassium rich foods. He would have had to have ingested a very unusual and high amount of potassium to had the severe spike that he did.
Thank you, Doctor. You can hear this. You just told us Mr. Bancroft had to have ingested a potassium-rich substance. But he didn't forget to regulate his potassium levels. So I want to talk about another possibility. Earlier you told us that only someone with chronic kidney disease could die from potassium. Did anyone know that Mr. Bancroft had chronic kidney disease?
Yes, according to Monsieur Bancroft's medical records, Taylor Hobson knew about his condition.
Were you on the train with Taylor Hobson?
I was.
Did you see the defendant Taylor Hobson wearing an orange hoodie?
Actually, now that you mention it, yes, I did.
All right, doctor. We should retrieve the bottle from the dirt.
Of course.
Now, I want to talk about something else in case. Let the record reflect, I'm showing opposing counsel. The bottle. And the lips. Now, doctor, does that look familiar to you?
Yes, actually, I saw Taylor Hobson in the store in Handorf holding a bottle that looked quite like this.
What's that on the label, doctor?
It says concentrated banana extract, 4 ounces, 48 doses.
48 doses, doctor. In your expert opinion, what would happen to Mr. Bancroft if he ingested this amount of concentrated banana extract?
Madame, if Monsieur Bancroft had consumed this amount of concentrated banana extract, I can conclude that he would have died just in the way he did. Same symptoms, same cardiac arrest, same escalation, exactly the same.
Thank you, doctor. I have no further questions. Permission to republish to the journal?
Sure. Any cross?
Yeah.
Permission to proceed?
Yes.
Good morning, Dr. Diamond.
Hello,
You dissolved your private practice in 2022, correct?
that's correct.
And this was due to reputational damage?
Yes,
And you would say that Bancroft had a hand in these damages, correct?
Monsieur Bancroft was a part of a campaign, a political campaign that ran advertisements, part of which involved mentioning a accidental tax incident I had, and that did damage my reputation, but that is all in the past.
But your reputation led to a loss of clients, correct?
It did.
And so you had to ultimately dissolve your private practice?
I did.
Now, when you boarded that train, you met Taylor Hobson, correct?
I did.
But your soured opinion of Avery Bancroft carried into a soured opinion of Taylor Hobson. Isn't that right?
Yes, I felt as though Taylor Hobson may, as a member of the Bancroft business, have been involved in the advertisements, but that is, again, all in the past.
But you boarded the train and met Taylor Hobson already having a soured opinion of him, didn't you? Or sorry.
Yes.
You did, right? Now let's move on to Schur's tools and crafts, or your excursion on Hamburg. Prior to your excursion, Ashley Connell asked you where she can find a bottle of potassium. Isn't that right?
Objection, Your Honor, to hearsay.
Oh, Your Honor, I may respond.
No, I'm thinking about it.
May I explain?
Sure.
Opposing counsel is bringing in a out-of-court statement and using it for the truth of the matter. I expect opposing counsel to argue that this line, that the quote that they're eliciting is a question, and so it's not a statement. But we would argue that even though the statement is in the form of a question, it still has truth value to it. In this instance, the truth value is that Ashley Connell knows what potassium is and is looking for a model of potassium. Just because it's in the form of a question doesn't mean it's not hearsay.
Could you repeat that question for me?
Yeah, sure. So prior to your excursion to Hamburg, Ashley Connell asked you where she can find potassium. Isn't that right?
You don't have to answer it, I just moved the question. And please excuse me, but Ashley is your client?
No, this is Taylor Hobson.
I'm sorry.
Ashley is who we believe killed Avery Bancroft.
You didn't have to go that.
Can I try to respond?
Yeah, of course.
Yeah, the question, where can I find potassium, has no truth value, as it does not go to whether Ashley did or did not find potassium, and it's simply just a question that Dr. Edmond could have responded to.
May I respond to this?
Yes.
Again, Your Honor, same argument. The fact that she's asking where can I find potassium assumes that one, there's truth value in the fact that there is potassium to be found, and two, that Ashley Connell was looking for it. It goes directly to the witness's motive.
She's actually testifying.
No.
I would take exceptions to, I understand your argument, I take exception to it, only because it's not what I would call a true functional question. The response doesn't require truth, or she could have answered it in a foreign language that no one understood. There was no reliance on her statement, which was of course the question. The purpose behind the hearsay rule is designed to allow people to cross-examine or to at least look into the truth or falsity of a response by that first person. This response is not true functional, so I would allow it for that reason.
Yes, Your Honor.
If I may.
Of course.
Let me repeat my question. So Ashley Connell asked you where she can find a bottle of potassium. Isn't that right?
Ashley Connell asked me where she could find a potassium supplement.
Yeah. And so you told her that she could find it in Andover, correct?
Yes, and she said she would not be able to go to Andover.
And so because she couldn't go, she asked, or she mentioned asking a friend where she to buy it for her. Isn't that right?
Objection, Your Honor, to hearsay.
That's going a little too far.
So,
Move to strike, Your Honor.
Did we get an answer? I'm sorry. I can strike the question, but the question's been disallowed.
All right, Your Honor.
so now let's move on to your time in Sheriff Susan Cobb. You mentioned you saw Taylor Hobson holding a bottle,
Yes.
and you say that it was the bottle of banana extract, is that right?
I say it resembled it, yes.
Permission to approach the witness with what has been labeled as Exhibit 40, the bottle.
I'll allow that.
We can use our copy in case you would like to reference.
Any objection to using the copy of the bottle?
Just noting for the record that it is a copy of the potassium extract, Your Honor.
Now, Dr. Edmond, on that bottle, is that a banana?
Yes, it is.
And are you 100% sure that that is a banana?
I am 100% sure that this is a banana.
But when you saw Taylor Hobson holding the bottle, you couldn't tell me if that was a banana or not?
I was fairly sure that this was a banana, but I was not there with Taylor Hobson, so not sure.
So you don't know if that was the same bottle that Taylor Hobson was holding, do you?
I do not know. No, I only speak of the resemblance.
Wait, and you didn't notice any other identifying factors of the bottle?
No, just that it resembled this one.
So when you had a conversation with Taylor Hobson and he put down the bottle, you didn't notice anything else about it?
No, I did not.
Not even the bright green label at the top of the bottle? You didn't notice that?
There are words on every bottle, however, there is not a banana on every bottle. That is the feature that most stood out to me when I saw the bottle.
So, just to be clear, you can't tell me that Taylor Hobson was holding that exact bottle, could you?
I cannot.
Now, let's also be clear. You did not see Taylor Hobson buying this bottle of potassium extract, did you?
I do not see that, no.
Alright. Now, lastly, let's go back to your time on the train. You had a conversation with Bancroft the day prior to his death, didn't you?
I did.
And in that conversation, he told you about his CPD?
Yes, he did.
And now, during this conversation, Ashley Connell was a few tables away from you, wasn't she?
I believe so, yes, she was sitting behind us.
And at some point, you cracked a joke to lessen the tension in the room?
Yes.
And when you said this joke, you saw Ashley Connell laughing along to your joke?
Objection, Your Honor, to speculation. May I explain?
I agree, actually. You don't have to explain. If you're asking him whether he knew whether he was laughing or she was laughing at that joke, he's not in a position to answer that. You're asking him if she laughed at or near the time that the punchline of the joke was asked. That would allow the jury to determine whether they think she was laughing to that or not. He's not in a position to answer that. The second question. He doesn't know what she was laughing at unless he's going to tell us that he does. But unless there was a subsequent conversation, that's never going to be known.
May I rephrase my question?
Of course.
Motion to strike that previous question.
I'll allow.
Alright. So you saw Ashley Connell laughing around the time that you cracked your joke. Isn't that right?
Yes, I made a joke, and then Ashley Connell was in conversation with a person named Zhang behind us, and they began to laugh in their conversation.
And is it within your reasonable or rational perception that she was within hearing distance of you?
I cannot be sure, but they were relatively close, yes.
Alright, no further questions.
No, to redirect, Your Honor, we just asked that Dr. Emmett be allowed to step down.
Okay. Thank you, Doctor. Next witness.
Yes, Your Honor. Plaintiff calls Jordan Nathanson to the stand. And as Ms. Nathanson takes the stand, may we set up a demonstrative as well?
Yes.
We have some help from co-counsel. Thank you. I'm sorry, this is a very small well. Would it be okay if I put it here? You would still be maybe able to see. Okay.
Your Honor?
Not working with very much space here. Okay.
Oh, I can't see.
Is this all right? Would you be able to move? I'm not sure exactly how to.
Your Honor, permission to reposition myself so I can see the demonstrable.
Sure.
And may I proceed, Your Honor?
Yeah, is it possible to put it somewhere else that would allow them to sit down and take notes more easily?
Yes.
Or, I mean, you can even move over here if you like.
Your Honor, I wouldn't mind moving over to that side if that's easier.
Right, that's what I was gonna suggest, and then that can go here, so we can see it from the side, they can see it.
Does this work for you?
Absolutely.
Okay. Wonderful.
Realize we're now in front of the camera, is that a problem?
Okay. May I proceed, Your Honor? Good morning. Please introduce yourself to the jury.
Hi, I'm Detective Jordan Nathanson, and I'm a private investigator.
How did you get into that line of work?
I worked at the FBI for a few decades, and I loved the thrill of it all. But when I saw my Naveen at the altar in uniform, and my daughter Anya graduated from Quantico, I realized it was time that I wanted to spend more time with my kids. So I opened a private practice of my own.
So how are you involved with today's case?
I was on the train, the Mid-Riverina Express, when Avery Bancroft passed away. And I was able to review some of the evidence with the police, and then I was hired to take another look.
I want to talk about your time on the train. When was the first time you saw the defendant?
I saw Miss Hobson at the welcome dinner on the train, but I admit we didn't talk at all. But then I saw her again the next day during the excursion.
Well, did you talk on that excursion?
No, I was enjoying the view. But I do remember a conversation between Miss Kim, a photojournalist I met on the train, and Miss Hobson.
What was that conversation?
Miss Kim was asking Miss Hobson about the rumor.
Objection, Your Honor, to hearsay. We asked to strike any testimony made by Harley Kim. We're fine with any testimony made by Taylor Hobson because they are the opposing party, but we asked to strike any testimony made by Harley Kim.
Can I be heard, Your Honor?
Sure.
The question that Ms. Nathanson is testifying to already came on the record. Ms. Kim already testified to asking the defendant this question. Furthermore, it's a question, it's not a statement, it contains no truth. And if I may proffer, the question is about a rumor of Avery Bancroft changing his will. The truth value, whether or not Mr. Bancroft actually wanted to change his will, makes no effect on our case. We're only showing the effect on the listener, the defendant, in that she gave a motive. But this question, has already come on the record via Ms. Kim's testimony.
I agree.
Yes, Your Honor.
Ms. Nathanson, I believe you were in the middle. Would you tell us just what that question you overheard was?
Sure. Miss Kim was asking about a rumor, and she said, "Is it true? Is your dad really writing you out of the will?"
And then how did the defendant react?
No. Miss Hobson, she looked like my husband when Anya brought home her first boyfriend. He was an influencer. Her expression, it completely changed. And then she walked out.
All right, so I want to talk about the next time that you saw the defendant. Can you tell the jury where you were at that moment?
Sure. I saw the defendant next when we were swapping, I was at the bar swapping stories with the bartender about Naveen's terrible twos. And then Miss Hobson, she came up and she was asking about some concentrated banana extract.
Banana extract. Ms. Nathanson, was this the last time banana extract came up?
No, we saw it again and again, including on a receipt that I had found on the train.
I want to talk about this receipt. Let the record reflect. I'm showing opposing counsel a copy of what's been pre-marked as Zip 31 and the witness a copy. Would Your Honor like a courtesy copy?
Yes, please.
Ms. Nathanson, what is this?
This is that receipt I was talking about. I found it with the police on the train. It was in a trash can.
And is it a fair and accurate copy of the receipt as you found it with the police?
Yes, looks to be so.
At this time, we move 31 into evidence, and we know two stipulations for Your Honor. Stipulation 7 indicates all hearsay objections have been waived, and stipulation 23 indicates that this receipt was found by the Australian police in a trash can on the train.
Is that your understanding?
Yes, Your Honor.
Okay, please proceed.
Your Honor, is this, when we assume this is so moved into evidence?
Yes.
So I move to constructively publish to the jury. Ms. Nathanson, can you tell us where this receipt is from?
Sure. This receipt was from one of the stores on the excursions that we went on the train.
And would you read for us what items are on this receipt?
Yes. Well, there's sunblock on here, sunglasses, and one concentrated banana extract.
I want to talk more about that banana extract. Ms. Nathanson, do you know who bought it?
Yes, I can tell you actually. I brought along a little poster to show you how I know.
May Ms. Nathanson step down and make use of her demonstrative?
Yes.
I'm excited for you to see this. I have practice with my kids' science fair projects.
So could you just explain to the jury, what are we looking at?
Well, here, this tracks where the passengers were during the purchase of that banana extract.
So walk us through the beginning of the timeline.
Sure. Well, at 6:30 p.m., 6 of the passengers had gone on an excursion to an art museum. I was one of them, and the other 6 went on an excursion to shop. So at 6:30 p.m., the excursion from the art museum returned back onto the train. At that time, 6 out of the 12 passengers were back on the express.
And then what happened between 6:45 and 6:55?
Well, between 6:45 and 6:55, that other excursion I mentioned, those passengers came onto the train. But only 5 out of the 6 of them returned. So by that time, 11 out of the 12 passengers were back.
And then what happened at 6:57?
Well, it's right there in front of you. At 6:57, that's when the purchase for the banana extract was made. And this time, it's important to note that there was still 1 passenger missing.
Who was that one passenger missing?
Well, that would be a passenger that didn't return until 6:59 p.m. And that would be Taylor Hobson.
Thank you, Ms. Nathanson. You may return to the stand. I can take these from you. Thank you. I just want to talk a bit more about this banana extract. Did you yourself ever see banana extract?
I did. I saw it in Taylor Hobson's cabin in an orange hoodie.
All right, let's back up here for a second. Why were you in the defendant's cabin?
Well, I was in the hallway, and then I overheard a conversation between Taylor Hobson and Kelly Dews. And at that time, they were talking about, "Don't go looking in my orange hoodie, I have a surprise for you," is what Miss Hobson said. And after that, they walked off and closed the door, but I noticed the door didn't shut all the way. So I went to shut it for them.
What did you see when you went to close the door?
Well, there was this orange hoodie that was blocking the door, and then I went to go fold it up, even though the kids had moved out, old habits die hard. But when I was going to fold it up, I noticed something.
Well, what did you notice?
Well, there was something in the hoodie, so I reached in and I pulled out a bottle of banana extract.
May I approach the witness and retender to the witness from the jury? Exhibit 40. Ms. Nathanson, does this look like the bottle that you saw in the orange hoodie?
Yes, this looks just like it.
Well, did you ever see banana extract again?
I did. It was the day after Avery Bancroft died. After the passengers left, I went back into Miss Hobson's cabin, and there it was. Except this time, the bottle and the hoodie, it was empty.
Thank you, Ms. Nathanson. Should to republish for the jury exhibit 40. And with that, we have no further questions.
Thank
Would
you.
you like us to leave this up or take it down?
You can leave it up.
Your Honor.
Oh, I'm sorry. I'll take you some minutes.
No problem. Permission to begin cross-examination?
Okay, thank you.
Good morning, Ms. Nathanson. My name is
Morning.
Monty, and I'm going to be asking you a few questions on behalf of the defense. So, as you mentioned earlier, you're the founder of Nathanson Investigations, right?
I am.
You're a private investigator.
Yes.
And as your job as a private investigator, you look for evidence, correct?
I do.
As a matter of fact, you search for evidence where it doesn't even exist. Is that right?
Yes, I'd like to say it's the decades of FBI experience that make me just so good at my job.
Right, so, Ms. Nathanson, one more time. You find evidence where it doesn't even exist. Is that a yes to my question?
Yes, I'm good at finding evidence.
Where it doesn't exist.
Sure, if that's how you'd like to put it.
Sure. Now, I'd like to talk to you about your relationship with Shannon Shahid. Now, you do about 3 to 4 cases for Mr. Shahid each year?
Yes.
And Mr. Shahid hired you to investigate the death of their father, is that right?
Yes, that was after the Mid-Riverina Express.
Absolutely. After their father died, they hired you to investigate their death.
Yes.
Would you recognize a copy of an email sent to you by Shannon Shahid?
I would.
Your Honor, permission to approach opposing counsel, the witness, and the bench with what's been marked as Exhibit 27, an email sent by Shannon Shahid to Jordan Nathanson.
Very well.
Would Your Honor like a courtesy copy?
I'm good.
Ms. Nathanson, do you recognize this document?
I do. I had volunteered this email during the investigation.
And this is an accurate copy, it's not been changed or altered in any way?
No?
Your Honor, permission to enter Exhibit 27 into evidence?
Any objection?
Your Honor, seeing as this is a party opponent, we have no questions.
Okay.
All right, Ms. Nathanson, please read quietly as I read aloud. Now, when Mr. Shannon Shahid was emailing you, in the first paragraph, they said, "I'd be happy to buy you a ticket to show my gratitude for all you've done for me." Is that correct?
Yes, that would be right, but I'd like to say, Counselor, that Mr. Shahid didn't buy that ticket for me. I was on the Mid-Riverina Express working on a different case for a different client.
Absolutely, but they offered to buy you that ticket to get you on the same train. That's right?
Yes,
He offered, Your Honor, to speculation maybe for,
Yes.
the reasoning why Mr. Shahid offered to buy Ms. Nathanson the ticket is not something she can testify to. That would cause her to enter the mindset of Mr. Shahid. She can say that he offered it, she can't explain exactly why he made this offer.
Your Honor, if I may respond on those grounds? I'm not asking the witness to testify to why Mr. Shahid asked the witness to board this train, just that they offered to buy a ticket.
Actually, I could have went beyond that as well.
If I may, Your Honor, the question asked if Mr. Shahid offered to buy this ticket to get Ms. Nathanson on the same train. We disagree with that categorization of the same train, as we can't understand which same Mr. Shahid was comparing it to, or why he offered this ticket specifically.
Your Honor, if I may respond on those grounds? Sure. The email states that the train that they were going to buy a ticket for is the Mid-Riverina Express. I'm just asking the witness if Mr. Shahid offered to buy a ticket for the MRE. I'm not asking them to testify to any reasoning beyond the fact that the offer was made to board this train.
I agree. I'll allow.
Thank you, Your Honor. Yes, Your Honor. So once again, Mr. Shahid offered to buy you a first-class ticket for the MRE, is that right?
Yes, but he never bought my ticket.
Right, well, let's move on to the second paragraph. In the first line, Mr. Shahid says, I'll admit, I do have a bit of an ulterior motive. My birth father has apparently been in Australia, and I just found out that he's gonna be on that train.
Objection to hearsay, if I may specifically to the statement, my birth father has apparently been in Australia, that implies somebody else told Mr. Shahid that Avery Bancroft would be in Australia. He says apparently, it's not something he himself knows. And so this is hearsay within this document.
Your Honor, this document's already been entered into evidence, and so the witness can testify to the materials within this document.
I agree.
Yes, Your Honor.
Now, once again, Mrs. Nathanson, Mr. Shahid says that I'll admit I have a bit of an ulterior motive. My birth father has apparently been in Australia, and I just found out that they're gonna be on this train.
Yes, and then he goes on to talk about, I don't know what's going to happen here, but I have a sense that somehow my half-sibling is involved. I don't know, Miss. Sure.
I'm not asking you about that. I'm simply asking you that Mr. Shahid had a bit of an ulterior motive, and they knew that their birth father was going to be on this train. Is that correct?
Well, I don't know for sure about that ulterior motive, counselor. Mr. Shahid himself is a bit of a psychic, so I couldn't tell you about those ramblings, but yes, I guess it says the words ulterior motive.
Sure. That's what this document says, correct?
Yes, there are the words ulterior motive on it.
And that was the same train that Avery Bancroft was going to be on. Is that correct?
Yes.
All right. And at the end, Mr. Shahid says, keep your eyes open for me. Did I read that right?
Yes.
All right, now I'd like to talk to you about how you're being compensated for this case. You're being paid a contingency fee, is that correct?
Yes, I believe 0.1% of the inheritance.
Right, you receive 0.1% of whatever Mr. Shannon Shahid inherits, is that right?
Yes, I didn't want to take any fee, but Mr. Shahid kept insisting, so I was okay with it.
Your Honor, I'd like to read 2 relevant stipulations onto the record.
Okay. Any objection?
No, Your Honor.
If I can direct your attention to stipulation 22, which states that at the time of his death, Avery Bancroft was worth approximately $404 million.
Understood.
And stipulation 29, which states that both parties agree that this trial is not bifurcated. If the plaintiff prevails in this case and the defendant is found liable, Shannon Shahid will inherit the entirety of Avery Bancroft's estate.
I understand.
Now, Ms. Nathanson, based on that information, you received 0.1% of $404 million. Is that right?
Yes.
So if Shannon Shahid wins, you get about $400,000.
If that's what it works out to, counselor, I don't know, my husband's the stay-at-home one, so he works out the numbers.
Sure, but if Shannon Shahid wins, you make $400,000. Is that right?
Sure.
But if Shannon Shahid loses, you don't make a single cent.
No, I'm comfortable. I've been with the FBI for decades. I didn't need the money.
So you either make $400,000 or you make nothing. Is that correct? Yes or no?
Yes.
Now, earlier you brought forth the timeline of the members on the train. Now, at 6:12, 6 people returned from the train.
Yes, and of those 6 people, there was Ashley O'Connell and a few other people as well that had returned back to the train.
Sure. And Miss Nathanson, did you go on this excursion?
Yes, I did.
And did you see Taylor Hobson purchasing this banana extract?
No, I didn't see the purchase of the banana extract. I just found the receipt for it.
Sure. Did you see Taylor Hobson holding this banana extract?
No, I did not at that time.
At any point on the train, once every passenger had arrived, did you ever see Taylor Hobson holding this banana extract? Yes or no?
No, but I saw it in her cap.
You never saw Taylor herself holding this banana extract?
No, I didn't.
Thank you, Your Honor. No further questions.
Brief redirect, Your Honor.
Yes.
Ms. Nathanson, I just want to turn your attention back to the email that you were looking at. I think you were reading aloud just that last sentence of the third paragraph there. Would you just read that for us?
Sure. Well, as I was saying before, with that ulterior motive, I don't know exactly what's going to happen here, but I sense that somehow my half-sibling is involved.
Thank you. That'll be all.
Anything?
None, Your Honor.
We ask Ms. Nathanson to speak at this time.
Thank you.
At this time, Your Honor, the plaintiff has no other witness to call. We rest our case in chief.
Okay, I think we go for a break, unless I'm mistaken.
Yeah, we can do 5 minutes or so, but just because we're running a little bit behind schedule, maybe tightening objection responses,
Okay.
explanations.
You have no more witnesses. Actually, are you going to make a motion on your case? Motion for directed verdict? Anything like that?
Typically at this point in trial, if the plaintiff has rested their case, we can move it into a short break and the defense can proceed.
Okay, that's what we'll do.
Yes.